My report emphasised that the Commonwealth should focus on truly national issues and avoid becoming a court of last resort for all environmental ills, no matter how concerning. I argue that the states should be held accountable for their decision-making or the lack of it. Too often, NGOs and the community try to draw on Big Brother in the form of the feds. Environmental outcomes will be better in the long run if the states are held to account politically for their systems and their decisions. At the time of my inquiry, there were already signs of business concerns, egged on by disgruntled states who had never been happy with the EPBC Act, that the Act was being triggered far too often for matters that were of only state or local significance. This, in turn, led the Business Council of Australia to conclude that the Commonwealth was overstepping its legitimate role and getting involved in matters which properly belonged to the states. For example, subdivisions in Western Australia and Victoria on the basis of urban fringe-threatened species such as green and gold bellfrogs and Carnaby's cockatoos. My report found that the Act had contributed significantly to improved environmental regulation, leading to important reforms to the way Commonwealth responsibilities were discharged and improved environmental outcomes for matters of national environmental significance. But I felt it needed to be more strategic, moving from reliance on individual project assessments and approvals to more landscape-scale approaches to achieving environmental outcomes. It took the Gillard government some 2 years to deliver its formal response to my report, so the amendment package stalled and never saw the light of day. What happened? You could say democracy intervened in the form of the 21 August 2010 election. Between handing down my report and the government's response, the ministry changed hands from Garrett to Burke, who took almost 12 months to come to his own views about my recommended reforms, and by then another election was looming. Not a good time to be embarking on detailed reform of environmental legislation. So the fundamental problem was still there. The Commonwealth became increasingly focused on project assessments and their implications, and less on national issues of ecological sustainability. Concerns about over-regulation and duplication mounted, and were given added impetus because Garrett, then Burke, knocked back or delayed some major resource development projects. This is the backdrop to why the ALP, and now the Coalition, embarked on a one-stop shop assessments and approvals bilaterals approach through COAG. Burke issued national standards for accreditation, which provided benchmarking that the states would have to meet, aimed at lifting their environmental performance. Gillard finally concluded that approvals bilaterals would not solve the problem because the states couldn't uniformly meet the national performance standards, and we would end up with a patchwork quilt of arrangements, creating even more uncertainty for developers. The solution still relied on improving Commonwealth practice. I had proposed accreditation as the way to focus attention on the big environment picture and lift national standards, although my pathway was to build trust through approval of bioregional plans and strategic assessments. Smaller steps with more certainty about outcomes. One of the EPBC Act's virtues is that it replaced uncertainty about what would be subject to Commonwealth regulation with a very rational set of triggers, namely significant impacts on specified matters of national environmental significance. Threatening this logical approach no matter how tempting, has serious consequences for national environmental regulations. Those who want the Commonwealth to have nothing to do with environmental regulation are never far below the surface. Given the vital role played by water in the ecological health of Australia, the EPBC review recommended a water trigger which would have brought about strategic assessment of water management plans, not individual projects. This recommendation was rejected by the ALP government. Under pressure to get involved in regulating coal seam gas developments, however, developments that didn't otherwise trigger the Act, Labor accepted Tony Windsor's proposal to create a partial water trigger dealing only with CSG, further complicating the relationship between the Commonwealth and the states because it involved a clause preventing devolution to the states and inflaming those who considered the Commonwealth was overreaching. I also proposed a greenhouse trigger as a way of dealing with another genuine national issue, greenhouse gases. Like water, many NGOs have been trying to extend the operation of the Act to this national problem, but by indirect means. My proposal was to establish an EPBC Act trigger to cover the gap until there was a viable market mechanism in place. The Gillard government rejected this idea because it didn't think there would be a regulatory gap. It was confidence in its market mechanism, and we all know the fate of that. Indeed, I think Rudd will come to regret not calling a double dissolution over what he called the defining challenge of our generation, one of the greatest moral, economic and environmental challenges of our age. So where to now? Is there still a case for a regulatory trigger as an interim measure pending a more systematic solution? Should large generators of greenhouse gases be allowed to use the atmosphere as a free resource without either facing a price or being regulated? No need to reprise the current federal government policy position. Greg Hunt's PhD thesis, A Tax to Make the Polluter Pay, argued the inevitability of a pollution tax. Cognitive dissonance beckons, but I'm inclined to give him the benefit of the doubt and assume he is playing a long game on the issue, which involves seeing direct action as a first step towards a market mechanism. Despite the desire of yesterday's intergenerational report, some Liberals, the National Party, Maurice Newman and Alan Jones, a carbon market mechanism isn't going to go away. By my count, this issue has featured in 6 leadership challenges since 2007. You'll all know that Turnbull lost the leadership by just 1 vote over this issue last time. More recently, Turnbull has said that direct action should be given a chance, begging the question of what follows in the event that it does not generate sufficient sequestration to meet our targets. What about the next phase of environmental legislation? How does the Commonwealth revert to what was recommended in the EPBC Act review, and/or how does the Commonwealth ensure that it only gets involved in genuine national issues? The myriad improvements to the EPBC Act that I recommended still await their fate. I'm less convinced, however, of the merit of pursuing a major legislative reform program in one hit. The nature of modern politics and the fractious state of debate makes it very difficult to build the bipartisanship required to navigate the Parliament. Better, in my opinion, to focus on improving practice, make a series of smaller, incremental amendments, and work to rebuild bipartisanship around the importance of the Commonwealth maintaining a national focus and avoid politicising state issues, no matter how tempting. In my view, the Commonwealth's role should move away from project by project environmental impact assessments and approvals towards landscape scale strategic assessments. To that end, accreditation of state systems is a vital element of improving environmental outcomes across the board. Assessments and approvals bilaterals may or may not come into being. They depend on the Senate's disallowable instrument process. It disturbs me that those campaigning against the bilaterals focus on the simplistic argument that they represent a reckless delegation of power to the states who, by the way, can't be trusted. Accreditation promises the creation of a system where all boats are lifted by the rising tide. The key lies in what's put in place to reassure the community that the states are, in fact, making sound decisions. We tend to ignore the fact that the existing agreements have only weak assurance frameworks based on senior official oversight and regular reviews, despite having seen how ineffectual these mechanisms can be in regional forest agreements. The last thing we need is for the assurance arrangements to be politicised. They must be at some distance from ministers, state and federal, based on independent performance auditing, not of individual decisions. These are always a matter of balance and judgment, but of the system as a whole. It surely isn't beyond our collective wit and wisdom to design an assurance system for bilaterals that meets these criteria, removes the Commonwealth from day-to-day decision making and places it in the role of national performance monitor. Thank you for listening.